And on the line with us is Professor Mary Wood. She is the Philip H. Knight Professor of Law and Faculty Director of Environmental and Natural Resources Law at the Law Center, at the University of Oregon School of Law. She's also the author of the book, Nature's Trust, Environmental Law for a New Ecological Age. OurChildren'sTrust.org is doing a lawsuit based on Professor Wood's writings and theories, and well, it's not even a theory, I suppose. In fact, let's just start with Professor Wood. If you could start out by telling us, number one, how's the OurChildren'sTrust.org lawsuit going? And number two, what is the legal theory that drives it?
Yes, well, the lawsuit has been 3 years in the making, and it was about to go to trial this last Monday, October 29th. And on the sort of at the midnight hour, the Department of Justice, representing the Trump administration, had filed an extraordinary petition for what's called writ of mandamus to the U.S. Supreme Court. And Justice Roberts put a temporary stay on the case to consider Department of Justice's arguments. And so October 29th, the kids were supposed to be in the courtroom here in the Federal District Court of Eugene for what's called the trial of the century, because it would be the first time that fossil fuel policy would actually meet climate science in court. That didn't happen, but there were rallies in support of the trial across the country, and now everybody's literally just waiting in suspense. The theories behind this, very simply, the youth are suing the Trump administration for its fossil fuel policy that is driving us towards climate collapse and an inhabitable country. And it's based on two premises. One, that there is a affirmative constitutional due process right to prevent the government from putting its citizens in such peril, affirmative peril, by approving drilling every day and coal mining and subsidizing fossil fuels. The second principle is based on the public trust, which is an old principle that has been in our country since the very beginning, and it's a very simple concept that government, as part of its function, has to hold natural resources that we survive on in trust for the people, for present and future generations. And as trustee, it just has to protect these resources so that they can continue supporting our survival and promote the endurance of our nation. So those are the two bases.
So I'd like to kind of open those up and look into them. Where in law or in the Constitution do you find the affirmative right not to be harmed by your government, essentially, or not for your government not to collaborate with industry or even allow industry to harm us?
Yeah, so the due process clause is in our Constitution, and most Americans know what that means, that government can't deprive us of due process, of key rights without due process of law, so life, liberty, property. And there's case law that says the government doesn't have a general duty to ensure our protection every day, it does have the duty not to take affirmative action that just puts citizens in peril. And so under that case law, the plaintiffs have constructed a very robust argument going back decades, looking at government documents that show, and these are all available to the public, that show that the government knew about this climate threat for decades and deliberately pursued a fossil fuel policy despite knowing about this threat. There's a shocking report that I just read a couple days ago. It was a memo to President Nixon from one of his closest advisors that outlined the dangers of climate change, said we've got to do something about this, otherwise, and this is almost a direct quote, goodbye Washington, goodbye New York, we don't have any data on Seattle.
Wow, I would love to see that. Our due process rights, I'm still, it's not, I mean, I understand the concept, but how does, due process is out of, is essentially out of this idea that if you are charged with something, you have access to the courts. I mean, we find these in the 5th, 6th, 7th, and 8th Amendments of the Constitution, or unless I'm misunderstanding due process itself. I don't see where it's explicit that the government can't harm you. Life, liberty, and the pursuit of happiness are from the Declaration, not the Constitution. What am I missing?
The Due Process Clause has been interpreted for 2 centuries by American courts and the Supreme Court, and so case law has clearly defined individual liberties that are protected by the Due Process Clause. And so some of those individual liberties, and there's many of them, but for example, personal security, family autonomy, equal protection. And so these are the liberties that courts over the past 2 centuries, and some are more modern, of course, have been determined to be protected under our Constitution by the Due Process Clause. And so the specific one I'm mentioning is the right to not be put in affirmative danger by government is a very explicit one in the case law. In other words, government doesn't have the general obligation to make us safe all the time, but it cannot take actions that put us in direct and immediate peril, knowing that that is the result of this action. So
is it that we are subsidizing the fossil fuel industry that's doing this? I mean, that's an aggressive action that the government is taking. Or is it simply allowing them to do what they're doing, or both?
There's actually a whole suite of government actions that the federal government takes every day. So it's not just subsidies. It's approving export projects and promoting those export projects of huge, massive quantities of fossil fuel. It is opening public lands to coal mining and fracking and drilling. It's opening, in fact, President Trump just opened up more offshore waters to oil drilling. It's all of those actions combined. And so while the American public sometimes thinks that, lawsuits like this are trying to just force government to act, it's actually more preventing government from taking those affirmative actions on a daily basis that put us all in danger.
So that's the due process argument. The other argument is of government as essentially holding our environment in trust. Can you explain that?
Yeah, this goes back to, it's called an attribute of sovereignty. It actually goes back to Roman times and the Institutes of Justinian. The public trust has reflections in legal systems all around the world. And it's just a very basic premise that citizens can easily understand that one of the very purposes of government is to protect the natural resources that society relies upon, and not protect it for just one generation or allow one generation to exploit those resources, but rather protect it as an endowment for future generations, which, by the way, are always coming into the present. Every time a baby's born, that was a future coming into the present. And so protect it as an endowment so that the country may endure. The founders of this country created the Constitution on the platform of the public trust. It was a well-known concept in England. It was imported into our law at a very early date in this country. One of the key cases was Illinois Central Railroad, which was 1892, but it was actually present in our legal system long before that. And so the premise is government just has to protect the resources we rely on for our survival so that the nation can endure. The founders didn't create the Constitution as a suicide pact.
So for somebody who is not schooled in the law and is trying to understand what we're talking about, can you give me an example of a time? I mean, is this, Teddy Roosevelt in the national parks? I mean, of when the government said, okay, we're going to act proactively on behalf of the public trust, as a trustee of the environment, of nature.
Sure. Well, typically it's the courts enforcing the public trust against government, because government is typically inclined to use its power for the benefit of private industries. So a great example is that Illinois Central case that I mentioned, and that was a case that arose when the Illinois legislature conveyed the entire Chicago waterfront to a railroad company. And the citizens back then in 1892 needed that waterfront for fishing and navigation and commerce. And the Supreme Court, in an opinion that is still the landmark opinion of this principle, said you can't do that. There are certain resources, including the shorefront, that are held in trust, implicitly held in public trust. And the legislature literally has no power to just give them away. The only time it can give them away is if it really promotes the purposes of the public trust and does not do substantial impairment to the remaining resources. So what the government is doing today is actually a repeat of Illinois Central in the atmosphere. It's sort of giving away public resources, fossil fuel resources, that are severely impairing our climate system.
Remarkable. Mary Wood, you're doing God's work. I hope we can continue this conversation as time goes on. And in fact, we didn't even have it. I'm sorry, we're hitting a hard break here. I can't control it. We haven't even talked about ourchildrenstrust.org. In fact, let's try to get you back right after the election. We'll continue the conversation. Is that all right?
Thank you so much.
Great. Thank you so much. Ourchildrenstrust.org.